Good morning. This is Tanisha Williams with the Florida Sheriff's Association, and on behalf of our President, Sheriff Mark Hunter, and Executive Director, Steve Casey, I'd like to welcome you to our 2018 Ethics Law Training. The Florida law provides that the constitutional officers must complete 4 hours of ethics training each year before December 31st and attest on financial disclosures that training has been completed. During the month of October, the FSA will be hosting a series of webinars that will meet the required ethics training for sheriffs. A sheriff can obtain the required 4-hour ethics training if he or she participates in the 4 live 1-hour webinars, or if he or she watches the recorded version of the webinar. As stated in the webinar notification, at the end of the training series, certificates of completion will be sent to those registered for each live webinar. If you watch the recorded version of the webinar, you will not receive a certificate. Instead, please have your training coordinator document your participation to include in your training file. Before we begin our training today, I'd like to remind you of a few housekeeping tips. Please mute your phones during the presentation. Please do not put the call on hold at any time. And at the end of the presentation, we will open up the line for questions. Joining us again on today to discuss Public Records Overview Part 2 is Mr. Wayne Evans. Wayne is a shareholder of the law firm Allen, Norton & Bloom and serves as the General Counsel for the Florida Sheriff's Association. He specializes in labor and employment practices representing management. Welcome, Wayne.
Thank you, Tanisha. Good morning, everybody. We're going to do our second part of our ethics discussion this morning. And just to recap what we covered last week, we focused on gifts last week primarily and the requirements of you as sheriffs with respect to accepting gifts and when to report them. We talked about gift being anything of value more than $100. You may recall that we discussed you can't take a gift from a vendor or a lobbyist. We also talked about, with regard to the reporting requirements, that if it was over $100 and it was from someone who was not prohibited, you would do that on your quarterly form on Form 9. You may recall we also discussed how you could avoid any of these issues with regard to the gifts by paying it down so that you got it under $100. You have 90 days to do that. So last week was principally about you all as reporting individuals and focusing on gifts. This time, we're going to talk principally about conflict of interest. And the code of ethics that we're going to cover today not only applies to you, but some of these provisions apply to members of your agency as well. So today, we're going to look at some of these provisions in the code of ethics that address misuse of your office, conflicting contractual relationships, conflicting employment relationships, the anti-nepotism laws, restrictions after you leave the agency on working for, say, a vendor and interacting with the sheriff's office to solicit business. That's where we're going today. So this is more of a different focus, and as you're going to see, so many of the provisions that we're going to talk about today with regard to the Code of Ethics really discuss whether there's a conflict between some relationship that you have with a business entity and the performance of your duties, or with respect to a member of your agency, the same thing, whether there's a conflict with regard to the performance of the duties in the sheriff's office and that with some business relationship. So let's go to another gift issue, and this is going to be prohibition with regard to solicitation of gifts from lobbyists or vendor. So this, since it's dealing with a reporting individual, speaks to you as the sheriff. And here, this statute, 112.3148, states that you as a reporting individual may not solicit a gift of any amount. So again, it's not just the gift like we talked about last week that's more than $100, but anything of any amount from a lobbyist or the partner firm, employer, or principal of a lobbyist or vendor. All right, so let's talk about an example. So all y'all Gator fans, so last week you beat LSU, and now you're excited that you'll run the table. You'll be in the SEC championship, and this is a stepping stone to the national championship. Without getting into the merits of that, you have a food services vendor who's headquartered in Atlanta, and you would love to go to the SEC championship, and so you hit up one of the guys that you know with the vendor and say you would love to have tickets to the SEC championship. That would be soliciting a gift. Now, if it's a little different, you say, hey, if y'all have got some tickets, I'd be happy to pay for it, and you pay for the face value of the tickets. That's not solicitation of a gift because, you know, you're paying for the tickets. So solicitation, where you're reaching out and you're taking the initiative and you're asking a vendor, a lobbyist, to give you something of any particular value would be a violation of that statute. Offering you pay your own way would not. Okay. All right, this is more of the same. This is now, in terms of what we're speaking of in this particular statute, this not only speaks to you, but it speaks to you or any member of your agency. Here, as you see, it prohibits you or any employee for asking or accepting anything of value based upon your understanding that will influence official action. So if you have a bid out or you intend to award a contract, you want to be careful about accepting anything of value in the interim, and we kind of talked about that last week, that may create the perception that it will influence your decision to award this gift. It'd be like not only your situation, but also if you had several members of your agency and y'all were going to purchase body cameras, for example. So you had 2 or 3 that were tasked with deciding which product best served the agency and which one they were going to recommend. Neither you nor any member of that agency would want to accept any favors. You want to stay away from meals, you want to stay away from tickets, you know, anything that would be of value that would appear to influence the final decision that's being made. Okay, this is an example of one that I found in the Commission of Ethics Advisory Opinions, and it's more along the same tone, where a state legislator was jammed up and had to defend some litigation, and so there was an opinion about whether or not he could solicit donations from lobbyists and what the restrictions were with regard to taking funds to help him with regard to his legal defense. And the ethics opinion said, well, he couldn't solicit donations, again, because that was prohibited, you know, under 112.3132, like we discussed. And if it was from a lobbyist, he couldn't take donations greater than $100, so he was prohibited from doing that. He could take donations for his legal defense fund from somebody else other than a lobbyist, but as we learned last week, that would be something of value for his benefit, so if it was more than $100, that was a gift that was required to be reported. Here's another statute that addresses unauthorized compensation that's also in 112.313, and this prohibits not only you but also an employee of your agency from accepting anything of value, again, based upon the circumstances, knowing that it's being given to influence official action. And, you know, the byword here is do look a gift horse in the mouth, so that, you know, if you're being offered a dinner or you're offered the tickets or whatever the case may be, and you've got a pending contract out there, be careful, and if in doubt, stay away from it so, you know, you don't invite the complaint. I found several opinions on this particular issue with regard to conflict and unauthorized compensation, and I thought we could go through a few of these as well, because there's been enough out here now that the Ethics Commission has looked at where we can get some guidance about some situations that may arise that we'll know whether or not it's going to be a problem under the Ethics Code or not. There was one where a Department of Transportation engineer wanted to contribute his expertise to go build a bridge in South America, there was an association, this National Steel Bridge Alliance, that was a nonprofit that was setting up this charitable effort. And the question that he raised was, would there be a problem, you know, with him volunteering his time, going over to South America, lending his efforts to contribute to the bridge building? And Ethics Commission said, no, that you're volunteering your services, you're not getting anything personal out of that, so that's not going to be problematic for you. I think that would also lend itself to members in your agency that want to work for Habitat for Humanity or some other nonprofit that's doing charitable efforts, that they could do that without concerns that there's going to be some, you know, blowback or pushback or violation of the ethics code. More to the point, and here's an issue that came up about a city commissioner whose son-in-law suffered a stroke. So there was a fund established to pay for the son-in-law and help out with the medical expenses. So the city commissioner asked for an opinion from the Ethics Commission about whether that was going to be a violation, whether that would be unauthorized compensation if this fund was set up to help out with the son's medical expenses and rehab. And the Ethics Commission said, as long as the city commissioner wasn't involved in soliciting the funds, if the city commissioner wasn't involved in the fundraising, you know, it was kind of like a GoFundMe, then that would not be unauthorized compensation under the ethics code. The other situation I want to talk about too, which is probably not uncommon, you know, for some of your deputies, question that was posed to the Ethics Commission: if officers are at an apartment complex and they get a break on the rent, and the quid pro quo is they get a break on the rent, but they're also responsible for providing some security services to the apartment complex, you know, responding to, you know, some disturbance that's there, and to add that law enforcement presence, is that considered unauthorized compensation? And the Ethics Commission said no. Their official duties wouldn't be influenced by the rent reduction, so therefore it was not unauthorized compensation for the purposes of the Ethics Code. In contrast, in giving this opinion, the Ethics Commission referred to an opinion that they gave about whether a deputy could be employed as a private investigator. And the Commission, in that earlier opinion, said a deputy cannot be employed as a private investigator because that would be a conflict with his or her duties. Another one that I'd share with you too is one that was posed to the Ethics Commission about a vehicle homicide expert, like a THI, who wanted to know whether or not he could be an expert witness for giving an opinion on an existing investigation and basically doing it for a firm where he'd be an expert witness for a law firm. So the Commission looked at it, and they had reviewed this issue previously, and they said, well, there are certain parameters here that would allow this to occur. First, the THI would have to be giving an opinion and not investigating. So let me repeat that. According to the Commission, he could not use his particular expertise to take the data to go out and investigate the accident or reinvestigate the accident and basically rely upon expertise or information that was not otherwise accessible to the public. So if he wasn't investigating but was giving an opinion on an investigation that was already done, that was the first part that would be okay. That would lead them to say, all right, you could do that. The second part would be that the THI could not be doing this within his jurisdiction. So I think this was a city cop, and anything that would be done, any litigation, would have to be with regard to something that occurred outside his investigation. So with those two caveats, that is, he wasn't investigating, only giving an opinion, and second, it would be with regard to a matter that was outside his jurisdiction, then as far as the Ethics Commission was concerned, there was no conflict. Now, all of y'all I know have got policies with regard to off-duty employment, and in most of the sheriff's offices that I'm familiar with, before one of your folks can be approved for off-duty employment, they have to submit a request, and it's reviewed to assure that you don't perceive a conflict. Now, nothing about this ethics opinion precludes you, as the sheriff, from having some heartburn with one of your folks hiring himself out as a consultant or as an expert witness, particularly even though it's going to be with regard to a matter outside your investigation. There is the potential for the opinion of your traffic homicide investigator to be in conflict with the opinion of a THI for another sheriff's office or another jurisdiction. So, you know, that's something that you would want to take into consideration. We're talking about how the Ethics Commission views it. How you all view it from a policy standpoint is something else completely different. Nothing about this dictates whether or not you should agree to allow, you know, your THI to hire himself out for that purpose. So that really is going to be ultimately your call. Okay. All right, so let's talk about misuse of public position. This one is more direct with regard to conflict, and there's a corrupt use element in here that is significant in terms of establishing a violation. So this is all in 112.313, and this particular statute sets forth several provisions in the Code of Ethics that we're going to talk about this morning. So this one states that no public officer or employee, so that could be a member of your agency, shall corruptly use or attempt to use his or her official position or any property or resource which may be within his or her trust to perform his or her official duties, secure special privilege, benefit, or exemption for himself, herself, or others. So note, this is directed towards using your office to get a specific benefit or a special privilege, not only for yourself, but for somebody else. So how does the Commission construe that, since we've got several elements in this? Well, the Commission says that they've got to find that there was use of the official position or attempted use to secure a special privilege benefit for yourself or somebody else. And that corruption is important. That element says with wrongful intent for the purpose of benefiting himself or another person from the same act or omission, inconsistent with the proper performance of the duties. So what's an example? All right, so you get a phone call from a good friend or from a campaign donor, and the phone call goes like this: hey, I've got a problem. My son just got picked up. He was with the wrong crowd. They got drugs. He's in jail. He's a good boy. He's never done anything wrong. He just got mixed up with the wrong group of folks. Is there anything that you can do to help us out? So you call the judge to get the bail reduced. That's not something you would do for anybody else, but you feel like, okay, well, good kid, you thought you'd put a word in for the judge, maybe to get this kid out on ROR. That's misuse of your position. You've intervened in that situation to get a special privilege for your friend's son, and arguably there's going to be circumstantial evidence of corrupt intent, even though you were just doing a favor. So, you know, you wouldn't want to put yourself in that particular position. There are other examples that we've seen from cases that have gone up before the Ethics Commission, and these should be pretty obvious to you. Inmate labor that's used at a private residence. So, you know, inmates go out to some property and they're doing some work, whether they're, you know, working on the yard or, you know, they're moving furniture or whatever the case may be. That's obviously improper. That's going to be considered misuse of the office every time. Many of your agencies have a purchasing card. You've got policies that dictate how that purchasing card can be used. And I'm pretty confident that those policies would preclude that card being used for any personal reasons. So if that card is used for buying meals, for doing something other than, for travel, picking up gifts, obviously that's going to be an issue. Same with using staff to assist in your campaign. That would be problematic as well. You're using your official position to get staff to help you. I'm not talking about volunteers after work. What I'm referring to is, during on-duty, having them, fold envelopes, work on campaign-related matters. Obviously, what they do off-duty volunteering for you is something else altogether and wouldn't necessarily be considered a violation. Okay. When we talk about honoraria, it's a little complicated, so let me take a couple of minutes and explain what we're talking about here. When I speak of an honorarium, this is a fee that's paid for a speaking engagement or for you to be writing, an article or, authoring a publication. So it's basically something that's given to you of value to, again, speak on some matter that's going to relate to your official duties. So when we cover this particular topic, and we're talking about what you can do and what you can't do, the honorarium is going to be something above and beyond payment of the expenses. It's essentially a reward, remuneration for, more often than not, giving a speech. So in this particular statute, payment of money or anything of value for a speech or other oral presentation for writing other than a book, which is intended to be published, and it excludes reasonable expenses. So that means if we're just talking about expenses, that's not an honorarium. So if somebody is paying for your hotel, you're out of town on a speaking engagement, you're doing it, for a national association that's asked you to speak, and so they're paying for your travel, that would not be an honorarium. Those expenses would not necessarily be in the same vein as being provided a speaker's fee for that. So this applies to you. Solicitation of payment by reporting individual, that's you, for a speaking engagement or writing related to your official duties is prohibited, so you can't ask for the fee. They call you up and say, hey, really would love to have you come down and speak on the opiate issue, or we've got some particular crime issue that's of importance. I appreciate it if you could come down and talk to the group about that. You can't solicit it. When we get into who can pay you and who can't, then there are some issues here too with regard to the expenses. And note that this applies to the performance of your official duties. If you've got some off-duty hobby and you're really good at fly fishing, for example, and they want you to come down and talk about fly fishing, then great. We're not worried here. It's not implicated because this just speaks to you talking about a given topic that relates to your official duties. So this is specifically what you can do and what you can't do. This statute prohibits you, the reporting individual, from accepting a fee from a lobbyist or vendor. Note, from a lobbyist or vendor. Again, just like we talked about last week, somebody who was working your agency to get a contract or compensated, by this communications group, this food service group, this medical services group, they're working you hard to get that contract, or it's somebody who's got a business relationship with your sheriff's office. So it prohibits you from getting a fee from a lobbyist or vendor for speaking, but they could pay your expenses. Again, transportation, so if it's airfare, they handle that. They take care of the hotel. They buy your meals. If there's a registration fee, they handle that as well. So the expenses can be covered, but you can't take a fee. So if invited, again, you can speak on a subject related to your official duties. They pay the expenses. There's no problem there. But if it is a vendor or if it's a lobbyist and they pay your expenses, there is a form, this Form 10, and you would fill that out. The lobbyist or the vendor, they're required to give you a breakdown on what the expenses were. So you take that and you put that on this particular form, and you attach it, to your annual financial disclosure form. Okay. All right. There are two of these statutes in 112.313, and they're similar, and they're both conflict of interest statutes. This one, Section 112.313, speaks to you, or like you've got civilian employee or somebody who's sworn who's in charge of purchasing for the agency. So either you and the sheriff may directly or indirectly purchase, rent, or lease any realty or goods or services from any business entity of which the sheriff or, again, the purchasing agent or spouse or the child, your spouse or your child, the spouse or the child of your purchasing agent is a partner, director, or proprietor with a material interest. Note that's pretty limited as far as the relatives are concerned. Again, spouse or child. So basically, what does this mean? Well, you can't do business with another business where you've got some material interest. You're a partner, you're a director, you're a proprietor. So it would be obvious that you would materially benefit, you would profit from any business relationship with that other business entity. So, I mean, that pretty well speaks for itself how that conflict would be, so that you're not shuffling business to some other entity where you're going to make some money off of it. Nor shall a sheriff or employee, while acting in a private capacity, rent, lease, or sell any realty goods. So that's obvious. Or services to the officers or employees' own agency. So again, it's all about conflict of interest, and that, again, is to preclude you or, the purchasing director for your agency from profiting from some business relationship with, a local firm, for example, automobile dealership or, whatever the case may be. There's an ethics opinion that's cited down there below, and this is helpful also to explain whether or not there's an issue with regard to part-time people. And it said it would apply to part-time uncompensated deputies if there's a conflict there, but it wouldn't apply necessarily to civilian volunteers, special deputies if they're not getting any compensation for it. Okay, so following up on that particular statute, your spouse has an office supply store. Well, you can't purchase from the office supply store. Your son's got a used car lot. Well, you're not going to be selling your used vehicles to the son's used car lot, so that's not going to work. So the next statute is similar because we've been talking about, business relationships, so this is similar with regard to conflict of interest. And this is a little broader, basically it's you or any member of the agency, and it precludes you or your employees, your deputies, from having some employment outside the sheriff's office or having a business relationship that create a conflict of interest. So, it would be, having a consulting service or something along those lines where there's clearly a recurring conflict between performing your duties or the duties of your employee and that of this other business relationship. So a couple of examples of what's okay and what's not. So, you have a real estate license, all right? So as long as you're not selling realty to, you know, the county for, you know, your office, you know, or leasing, you're okay. That would be true if you had an insurance company. So you've got an insurance company, and as long as that insurance company isn't marketing to the sheriff's office, there's no conflict there, and it would be okay. Obviously, you couldn't have a towing business. You know, you want to be really, really careful about any business venture that you get into where there's a perception that there is some conflict with your agency that's going to invite a complaint. You know, quite frankly, it's not worth it, and I talked about it last week. If there's a violation, the commission can assess fines, and the damage that's done, you know, in terms of the publicity and having the ethics complaint is just really irreparable. I do want to point out, I get calls from time to time about whether there would be a conflicting employment or contractual relationship, sometimes with regard to doing business, you know, with an agency. And I will say, okay, this is how I read it, but look, if you're going to do this, if I were you, I would ask for an opinion from the Ethics Commission. They do this. You can request it. If there's an employee in your agency that's about to get into this business venture, they'll write an opinion for that employee. It's really better to have that in hand before, you know, you establish that relationship, and then you get the complaint, and now after the fact, you're having to justify it. Just one twist on this, if there's a relationship with a nonprofit, and even if that nonprofit has some business relationship with the sheriff's office, if you're not getting any money from it or profit from it, that may be okay. Again, that might be one where I would say, look, just to be safe, you better run that by the Ethics Commission and let them clear it for you. And there's a sole source exception, and so let me talk about this because under the Ethics Code, if there's only one business entity in your area that has what you need, then that is an exception to the prohibitions of selling, you know, to a member of the agency who's got that business relationship. So here, this was a deputy who had these high visibility badge holders, and he did the right thing, asked for an opinion from the Ethics Commission as to whether or not if his company sold those badge holders to the sheriff's office, that would be a violation, you know, of a conflicting employment or contractual relationship. And the Ethics Commission said, if it is sole source, then you're okay. That wouldn't be a violation. The other thing I want to talk about, too, is I want to bring up competitive bidding. I've covered this before when we've had sheriff's conferences, and I've said repeatedly that as a constitutional officer, you're not required to competitively bid. That's true. But you should also be aware that in the same statute we've been talking about, 112.313, that statute that sets forth these provisions of conflicting employment or contractual relationship, doing business with one agency, in subsection 12 of that statute, it provides that if you engage in the competitive bid process, that would be a defense to an ethics complaint, provided that you take what the Commission says is the lowest or the best bid. So if you're not involved in influencing the outcome of that competitive bid process, they put the bids out there, and again, if we're just talking about body cameras, for example, and you've got a competitive bid process and you get 4 that have responded to the invitation to bid, and you've got some specific criteria, and there's only one that meets that particular criteria, you select them, and there's an ethics complaint based upon, some allegation of, relative or whatever the case may be, that is a defense to the complaint that comes in. So there are occasions where, the competitive bid process will protect you, for high-value items. I certainly recommend it, but it's something for you to be aware of. Maybe one of those where if in doubt and you've got the time, be a good idea for you to go ahead and to go through that, do an invitation to bid, so that if there's an award, particularly if a relative's got a company who's going to be bidding on it, you would want that to protect yourself. Okay, what about employment restrictions after elected office? Basically, it's 2 years. So you retire from the sheriff's office and a vendor decides to offer you a position, likes the contacts that you've got with the other sheriffs, and thinks that this would be mutually beneficial. You've got something to do leaving the sheriff's office. It gives you an opportunity to maintain contacts with your fellow sheriffs, and it's beneficial for the vendor as well because you've got access. So what about it? Well, you can accept the position, you just can't interact with your former sheriff's office for 2 years. That's the period of time that is specified by this statute in 112.313. After the 2 years have expired, you're okay. I get a call from time to time on the nepotism laws, so let's just talk about this for a couple of minutes. Short story is, if you come into office and you have a relative that is already there, that relative has got a job. Nothing in the nepotism law says that you've got to fire that relative. The problem for the son or the daughter, the brother, the other relative that's covered by this particular statute is as long as you're in office, that child, that relative is never going to get promoted, because that's what the law prohibits. You can't hire and you can't promote. So they keep the job, but if your son's a deputy and you become the sheriff, your son's going to be a deputy sheriff for as long as you're sheriff. Other assignments may be available, SWAT, I think the question is going to be whether or not something would be an advancement in rank. If it's, a detective and it's a lateral, they don't get stripes, they don't have any supervisory authority, you could probably get away with that. That may be one where you want to get an opinion from the Ethics Commission. I think you'd probably be okay. But certainly any advancement in rank is going to be prohibited. And that is going to be true, too. Even if you think you've got a process in place that relies on objective criteria, that ranks, based in specific order, through written examination, through oral interviews, and you've got a committee that gives you 1 through 5. They're top 5 in order, and so you go right to the top, and it turns out to be your son, and your position is, hey, I didn't make that recommendation, they did. The trouble is, if you sign off on it, that's a promotion. So unless you're willing to delegate that authority away, which is, I think, a bad idea for a whole lot of other reasons, your son is not going to be able to be promoted, even if he goes through that promotional process and he's ranked number 1 based upon this process that's in place, regardless of how objective it is. So you can look at the definition of relative. It's there, and if there's ever a question, it's basically everybody other than a second or third cousin or distant relative. So that's pretty inclusive in terms of who's prohibited from being hired and who's prohibited from being promoted. And as you'll see in this anti-nepotism law, you can't hire them and you can't promote them, so they can't advance them in rank. So what about volunteers? So you've got a son, he goes through the academy, He's got another job, and so he really would like to get on and you know, have his law enforcement certification, and he wants to work as auxiliary or reserves or whatever the volunteer unit you have in your sheriff's office. What about that? Well, here's the problem. In many of your sheriff's offices, if there's an auxiliary outfit for your sheriff's office, they work a detail, they get paid. So that won't work. If your auxiliary gets paid, that's not going to work. If they don't get paid and they're strictly volunteering their services, if training expenses can be reimbursed by the agency, that's not a problem, that's not compensation, so that's okay. But if there is any compensation at all to the auxiliary or to the reserves, then you can't hire them because that's going to be a violation of the statute. Okay, so let's talk a little bit about the process and what the authority is of the Ethics Commission. We've gone through and talked about these conflict of interest provisions and nepotism law and the like. So I indicated to you before, they've got the authority to impose fines, and when they get to that point, they can actually garnish wages and the like. Hopefully y'all have never been through this process, and you never do, but in a few minutes or less, let me just tell you how this thing works. If you're in the fund, I told you last week it's covered in terms of the legal defense. I handle these for the sheriffs and been doing it for a while. I can say that it's confidential from the point that the complaint comes in through the hearing by the commission where they decide whether there's probable cause or not. There's a complaint. The Commission on Ethics assigns the complaint if the executive director determines that there's legal sufficiency. It goes to an investigator. The investigator will interview any witnesses, including the complainant, if the complainant has any knowledge of the facts. Once that's done, and I'm involved in that, and I'm present when you're interviewed, there's a report of the investigation that's done by the Commission on Ethics investigator. It's nothing but a fact-finding. That report of the investigation goes to an advocate for the Commission on Ethics, who is with the Attorney General's office assigned to the Commission on Ethics. That advocate reviews the report and makes a recommendation to the Commission as to whether or not there's a violation of the Code of Ethics. The advocate doesn't have the last word. It's nothing but a recommendation. We have the opportunity to respond to the report of the investigation so that if something was left out that's material, we can point that out. When the advocate's recommendation is made, we have an opportunity to respond to that as well, and we say that the advocate got it wrong, we can indicate, no, that's not correct. The facts don't support that particular recommendation. So at the hearing before the Commission on Ethics, there's an opportunity for me as your counsel to speak after the report is presented by the advocate. The Commission usually asks some questions and then they vote, and if there is a no probable cause determination by the Commission, you're done. Nothing further occurs. They do a report. That's a public record. It's over. If the Commission finds probable cause, the process is still ongoing at that point. Then the Commission on Ethics assigns this complaint, or transfers it, if you will, to the Division of Administrative Hearings, and there will be an evidentiary hearing conducted by a Division of Administrative Hearings administrative judge. Discovery is permitted, so on the few occasions where we've had to go through this, I've had depositions of witnesses. Sometimes the advocate takes the deposition of the sheriff. We go to a hearing. It's no different from any other quasi-judicial process. You know, you have opening statements, evidence is put on, direct, cross-examine, and then when that's done, proposed order is submitted to the administrative law judge, and then the administrative law judge does a recommended order to the Commission on Ethics. They take that, they meet again, and at another public hearing, the Commission on Ethics takes that recommended order from the administrative law judge, and they decide whether or not they're going to accept it and make a final determination as to whether or not there's been a violation of the Code of Ethics. When that is done, then there's an opportunity for an appeal to the First District Court of Appeal. I've done that before. I've had some limited success. I can tell you the one occasion that I've gone up to the DCA, it actually wasn't because of, I got a bad ruling from the Commission on Ethics with regard to the outcome. It was very favorable for the sheriff, but we took it up because the commission wouldn't give me fees. We thought that it was frivolous, that the complainant had misstated the facts and knowingly done so, but it's much like the judicial process. It's really hard to get an attorney's fee award, and I went to the First District Court of Appeal saying that the commission erred in denying us an award of fees, and the First DCA sided with the Commission on Ethics. So if you are the subject of a complaint and you feel that this is done for political reasons, that, you know, the facts have been misstated and you come out well in the end, we can ask for them, but I can tell you based upon personal experience, it's unlikely that we'll get an award. Also, if there's a conviction of a felony for breach of the public trust, that's forfeiture of the retirement, and that unfortunately has been the result for one or two sheriffs in past history. This is the provision with regard to the ethics training, and that's why you're spending an hour with me as opposed to doing something else that you would probably prefer to be doing. We're going to do 2 more hours on public records to satisfy that particular requirement, and that'll be beginning next week. Okay, we did this last week. We did a few scenarios to talk about gifts, so I'm going to do a few now to pull together our training with regard to conflict of interest. So let's start with this one, and it's based upon, unfortunately, a complaint that was brought to the Ethics Commission years ago. So here's a sheriff that goes to an FSA conference, takes his agency vehicle, and then decides he's going to go to vacation after the conference and take the agency vehicle out of state. There's a policy that says you can't use the vehicle for personal reasons, but the sheriff, after he got the ethics complaint, said, look, I'm on duty 24/7. You never know when I'm going to have to leave immediately to get back to the sheriff's office. So it was okay for me to take my vehicle out of state on vacation. That was a really bad idea because the commission didn't buy it, and my recommendation would be get a rental car or use your personal vehicle. It certainly beats the fine. And that's exactly what transpired because that was determined to be misuse of position, and consequently, the sheriff paid for it. Next scenario. This is an honorarium example. So you speak at a conference, let's say, and it's sponsored by Rotary on gang violence. So they pay for the hotel, and they give you a $150 gift certificate. Here we go. They give you a $150 gift certificate to Bass Pro Shop. That's a good thing. So what about this? Is there anything about this that's problematic? First of all, with regard to the expenses, okay? So they pay for the expenses. Don't have to worry about that. It's Rotary. That's not a vendor. You don't have to report it. That's the good news. But that's a $150 gift certificate. That's a gift. That's more than $100. So you've got to report the gift certificate on your quarterly report. All right, next. Okay, so your wife has an art gallery and sheriff's office looking for some art. Hers, boy, it would just be a perfect fit in the lobby. Can't really find anything else that just has that special touch to it. That's a problem. Don't do it because that's an obvious conflict due to the contractual relationship and the fact that your spouse owns the gallery by something else. Okay. Here's deputy's got a business on the side, and he's, following cheating spouses and gets paid for it off duty. What about that? That's obviously a conflict of interest, and I would presume that if that deputy went through channels pursuant to your policy and asked you for permission to do it, you would deny it and wouldn't give him the authority to do it under the sheriff's office. Keep in mind that it's a violation of the ethics code as well. All right. So here's another one, and this goes back to what I was saying before. This relates to nepotism. So you delegated your authority to a promotional board. So the board selects the sheriff's son as the top candidate for sergeant. The sheriff signs personnel action form and related documents appointing son as a sergeant. Well, problem is the fact that you signed the PAF because even though that board recommended your son, you were the one that ultimately promoted the son, so therefore that's a violation of the nepotism law. Here's another nepotism one, and you take office, your son's a sergeant, and so there's outrage by a member of the public knowing that your son's a sergeant and demands that you dismiss the sergeant, and as we stated before, no, your sergeant son keeps the job. He's just going to be a sergeant as long as you're the sheriff. You're picked up by a vendor, jail food services vendor, to be the goodwill ambassador at other sheriff's offices. What about that? That's okay, but you're not going to interact with your former sheriff's office for 2 years. And last one that we got here, your brother-in-law acquires an interest in local vendors selling ammunition to the sheriff's office. That's not a violation because necessarily because of the brother-in-law. I don't know that it's a really good idea. If I were you, I would do a competitive bid process and encourage your brother, if he wants the job, to go through that. That will much better protect you in the event of a complaint. And that's how I see that. So a couple of resources here for you all if you want to get a little more information on it, or I'm available for a phone call. And we may have some questions. Got 5 minutes for that, so we'll take some calls.
Okay, do we have any questions? No questions at all? Okay, well.
Wayne, you did such a great job. You have no questions. That's awesome.
or everybody's asleep, and maybe that's it. Maybe they nodded off after the first 15 or 20 minutes. I don't know, but anyway, I hope you all got something out of it. And again, this is a hot topic thing, and if there was ever a time to call, if you ever have an issue, please give me a ring. Sometimes I'll reach out to the Ethics Commission. Those folks are just great. They're very, very good about weighing in on these things, even informally. And so when I have a question, I call them to see if there's anything I missed. So I'm going to leave it at that. Kind of last but not least, all of us that are in North Florida have got Michael in a day or so. So I'm hoping everybody comes out all well and good, and y'all stay safe.
All right. If there's no further questions.
Hey.
Good job, man.
Well, appreciate it. Thank y'all so much.
Thank you, Wayne. Have a good day.
Thank you.